In this subunit, we're going to discuss the UCC approach to performance and breach. All right, now we come to everybody's favorite subunit. What is the UCC approach to this particular issue? So what is the UCC approach to performance and breach? These are the topics we're going to discuss here. The order of performance. Who has to go first, buyer or seller? What is buyer's right to reject the goods when the seller delivers non-conforming goods? Does seller have a right to cure her breach? What is seller's right to revoke her acceptance of the goods? We'll talk about that, and we'll explain what it means to revoke acceptance. How do we deal with installment contracts, performance and breach under installment contracts, and what is the UCC approach to anticipatory repudiation? Let's jump in. All right, our first topic, what is the order of performance of buyer and seller? Remember, buyer promises to buy the goods, seller promises to sell the goods. Naturally, buyer's promise to buy means a promise to pay. Seller promises to deliver the goods. Who goes first? Well, remember what we talked about in in common law, constructive conditions. Is this a constructive condition concurrent, where both parties have to perform at the same time? Or is it a constructive condition precedent, where one party has to perform before the other party? Well, let's look at what UCC says. Okay, so in UCC 2-511, unless otherwise agreed, tender of payment is a condition to the seller's duty to tender and complete any delivery. So what does this mean? Well, if you just read this in isolation, it means that buyer has to pay first before seller has to deliver the goods. It says seller's delivery is conditioned on buyer's payment. So this alone seems like this is a constructive condition precedent, where buyer has to go first, buyer has to pay first. But if you flip around the UCC, and this is kind of a Butler did it type of 2-507 says, tender of delivery is a condition to the buyer's duty to accept the goods, and unless otherwise agreed, to his duty to pay for them. In other words, what this is saying in isolation is that buyer's duty to pay for the goods is conditioned on seller's delivery of the goods. So which one is it? Well, if you read them together, they're constructive conditions concurrent. They have to happen at the same time. All right, let's talk about buyer's rejection of the goods. So here's an example. Buyer orders 100 light bulbs and seller delivers 96 light bulbs. Before we talk about the UCC approach, let's talk about the common law approach. Under the common law, could the buyer say, nope, I'm canceling the contract, you're in breach? Well, the answer is no. Why? Because it's a minor breach, right? At least the way I've drafted the fact pattern, seems to me like delivering 96 out of 100 light bulbs is a minor breach. And this means that under the common law, seller has substantially performed. If seller has substantially performed, buyer can sue for the minor breach, but buyer cannot cancel the contract and walk away from the contract. Well, what is the UCC approach? Well, the UCC says this: if the goods or the tender of delivery fail in any respect to conform to the contract, the buyer may reject the whole. Look at that. Fail in any respect to conform. In our example, did the seller's delivery fail in any respect to conform to the contract? Yes, it failed to conform to the contract, right? Seller only delivered 96. The contract was for 100 light bulbs. So this is what we call the perfect tender rule. The UCC does not adopt a material breach standard. And then we'll look at exceptions in a second, but let's just say this. The UCC does not adopt a material breach standard for seller's performance. Seller must strictly perform. It is called perfect tender. All right, so we understand that seller must strictly perform. Seller must tender perfect tender. Seller must tender perfectly. That's what I was trying to say. If seller does not tender perfectly, buyer has an opportunity to reject the goods and sue for breach. So it's very important that seller have an opportunity to cure. And the UCC does give seller the right to cure. So let's look at a couple different fact patterns. So buyer orders 100 light bulbs, 75 luminums, whatever luminums are, right? No one goes by watts anymore, they're luminums. I don't know if I can even say it right. In any case, just let's go with that. 75 luminums, delivery by October 12th. Now what happens? Seller delivers 100 light bulbs, but they're not 75 luminum light bulbs, they're 60 luminum light bulbs. All right, so is seller in breach? Yes. Has seller perfectly tendered? No. Can buyer reject the goods? Yes. Will seller have a right to cure? Well, let's see what the UCC says. 2-508 gives seller a right to cure under two circumstances, one or the other. If there is still time remaining under the contract, seller has a right to cure her breach. If seller had a reasonable belief that the non-conforming tender would be acceptable to buyer, then seller also has a right to cure her breach. Let's kind of look at two scenarios and work our way through the statutory provision. So in scenario A, seller delivers 100 light bulbs of only 60 luminums, right? And the contract was for 75 luminums on October 6th. Well, look at the original contract. The original contract called for delivery by October 12th. Seller has non-conforming tender on October 6th. Is seller in breach? Yes. Has seller tendered perfectly? No. May buyer reject the goods? Yes. Does seller have an opportunity to cure? Yes. Why? Well, look at that first one. If there's time remaining under the contract, seller has the opportunity to cure. And there is 6 days remaining under the contract. Scenario B. Seller delivers 100 light bulbs, 60 luminums on October 12th. Well, is there time remaining under the contract? No. But if seller had a reasonable belief that the 60 luminum light bulbs would be acceptable to buyer, then seller will have an opportunity to cure. Seller doesn't have to be right about that. She just has to have a reasonable belief. What could give her a reasonable belief? Well, past dealings with the buyer. Maybe in the past, buyer has accepted 60 aluminum light bulbs, or maybe seller knows that buyer has a need for all different types of light bulbs. Buyer is a light bulb merchandiser, and they have 100 aluminum light bulbs and 60 aluminum light bulbs, and they have all different types of light bulbs. So seller says, you know what, I know they need 60 aluminum light bulbs, so I'll send them this, right? This gives seller a reasonable belief that the non-conforming tender would be acceptable to buyer. And when buyer says, no, this is not acceptable to me, seller will have the opportunity to cure, even if there is no time remaining under the contract. All right, let's talk about revocation of acceptance, buyer's revocation of acceptance. Here's the general situation when buyer accepts goods, but the goods are non-conforming. So here's an example. Buyer orders 1,000 widgets, seller delivers 1,000 widgets, but 100 of them are defective. Buyer signs for the goods and puts them in storage. Okay, so buyer has not rejected the goods. Buyer has accepted the goods. And you might say, what does it mean to accept the goods? Well, you can read 2-606 and you get a full understanding of what it means to accept the goods. But effectively, if you do not reject the goods, you have accepted them. It's that simple. All right. So buyer, of course, can sue for breach. Buyer has accepted the goods are non-conforming, seller's in breach, buyer can sue for the breach. But the question is, can buyer revoke her acceptance? Buyer can no longer reject the goods. Once you have accepted the goods, you can no longer reject them. What buyer wants to do is to revoke her acceptance and say, hey, I'm revoking my acceptance, which is effectively the same as rejecting, but it happens after acceptance. But there's a different standard for revocation of acceptance. When can buyer revoke her acceptance because the goods are non-conforming. Well, 2-608 says buyer can revoke her acceptance if she has accepted the goods knowing of the nonconformity, but she reasonably believed that seller would cure the nonconformity, and seller has not cured the nonconformity, right? So for whatever reason, buyer noticed the nonconformity. In this case, we don't have facts about that, but seller delivered 1,000 widgets. 100 of them were defective. Let's assume that buyer knew that the goods were defective. Some of them were defective, and she accepted the goods anyway. Can she revoke her acceptance? Well, it depends. Did she reasonably believe that seller would cure the nonconformity? Right? And seller hasn't cured the nonconformity. Then she can revoke her acceptance. Or maybe she accepted the goods not knowing of the nonconformity. If she did that and it was difficult for her to discover the nonconformity, or because maybe the seller said, oh, no, they're conforming, trust me, well, then she can revoke her acceptance. So let's look at our fact pattern. Seller delivers 1,000 widgets. 100 of them are non-conforming. Maybe it was difficult for buyer to discover that 100 of them were defective, right? So maybe when you get delivered, when 1,000 widgets are delivered to you, you do a sample of like 5 to see if they're conforming. Well, maybe the 5 on the top were all functioning well, and the defective ones were all on the bottom. If that's the case, she accepted the goods without knowing of the nonconformity, and the nonconformity was difficult to discover, then she can revoke her acceptance. Okay, but there's one other really, really important thing that you have to know about revocation of acceptance, that the standard is not perfect tender. Okay? The standard is, and this is what the UCC says, the buyer may only revoke her acceptance if the nonconformity substantially impaired the value to her. Substantially impaired the value. Looks like a material breach standard. It is a material breach standard. So, if the seller delivers non-conforming goods, or if seller's tender is non-conforming to the contract in any way, even a little deviation, buyer can reject the goods. But if buyer accepts the goods, and then buyer later wants to revoke her acceptance because of a non-conformity, the non-conformity must be a material breach. Now, in our fact pattern, we have 100 out of the 1,000 are non-conforming. Is that a material breach? Is that substantially impairs the value to her? I don't think so. It's only 10%. Maybe it is. It's a close case. But in any case, the standard is material breach. Now, don't forget that if you accept goods and they're non-conforming, even if you don't revoke your acceptance, you can sue the seller for breach. All right, moving on. Let's talk about installment contracts. And you can see way at the bottom, it already says that it's a material breach standard. Okay, so I gave it away at the beginning, but let's go through it anyway. All right, so here is the situation. Buyer orders 1,200 light bulbs, 100 per month for 12 months. Seller delivers 96 for the first installment. So you can see that this is an installment contract. We have 1,200 light bulbs, and they're going to be shipped in installments, 100 a month for 12 months. In the first installment, seller delivers 96. Now, is this perfect tender? No. May buyer reject the installment? Well, the answer is no. Buyer may not reject the installment. The rule is that buyer may reject an installment only if the nonconformity substantially impairs the value to her. Here, it looks like she's only missing 4 light bulbs. It's difficult to make an argument that missing 4 out of 100 substantially impairs the value to her. Maybe she can convince us, but with no other facts, it looks like that this is not a material breach. So for installment contracts, we do not use the perfect tender rule. We use the substantially impairs the value to her. We use a material breach standard. The second question is, When can buyer cancel the entire contract? Well, if you look at 2-612 sub 3, it says whenever nonconformity or default with respect to one or more installments substantially impairs the value of the whole contract, there is the breach of the whole. In other words, if seller breaches enough of the entire contract to substantially impair the value of the entire contract, then and only then can then and only then can buyer walk away from the contract. Can buyer cancel the contract because of seller's breach? This is the installment contract situation. We use a material breach standard. Okay, finally, let's talk about the UCC approach to anticipatory repudiation. It's not real difficult. In fact, it is consistent with the common law approach. So 2-610 and 2-611 under the UCC deals with anticipatory repudiation, and 2-609 deals with reasonable assurances. But you should have a question that you want to ask me now, right? Is anticipatory repudiation a perfect tender standard or a material breach standard, right? What if I'm the seller and I say, sorry, I won't be able to deliver 1,000 widgets to you. I'll only be able to deliver 999. Is that an anticipatory repudiation standard? Excuse me, is that an anticipatory repudiation? Remember, our standard under the common law was that the anticipatory repudiation had to be a repudiation that would be a material breach. Here, I'm saying that I'm not going to be able to deliver 1 out of 1,000 widgets. Doesn't seem to be material breach. So, is it perfect tender? No. But is it anticipatory repudiation? Well, the UCC adopts, and if you look at the language, that the anticipatory repudiation has to substantially impair the value of the contract. In other words, it's a material breach standard. So when seller under the UCC says, I know I promised to sell you 1,000, but I'm only going to be able to deliver 999, that is not anticipatory repudiation.